Good evening, everybody, and welcome. Welcome to this evening. My name is Jill Cracknell, and I'm the Executive Director of CPAWS Yukon. I'd like to acknowledge that we're meeting here tonight on the traditional territory of the Kwanlin First Nation and Ta'an, Hwëch'in. And I'd like to welcome everybody who's online through the live streaming camera. We've heard that communities are gathering in Dawson and Mayo, Aklavik, Inuvik, and I think Fort McPherson. And there will be, no doubt, other people listening online at home. So welcome to all of you. And with me on the panel this evening for this discussion of the Peel Court decision and the appeal, we'll have Chief Ed Champion from the Na-Cho. Chief Roberta Joseph from Hwëch'in. And Christina MacDonald, who is Executive Director of the Yukon Conservation Society. And we represent the 4 plaintiffs who took the case to court, of course, and we are now, I understand, the respondents on the appeal. And we will start with a prayer, and Jimmy Johnny is going to lead the prayer for us.
Na-Cho. I want to do a prayer in my language, Northern Shoshone. Tonti, Na-Cho, Tsatsitsinja, Tlakuta Kantunu, Tangi, Tiada Yuda Troan, Hunya, Teatru, Tating, Sotan Kinite, Tasoni thing. Agency, Tige, Se Denetro Tige, Kitano Teonian, the Kesi, Setting Touches and Da. I'm going to say my English. Almighty, thank you for this meeting. We all gathered here tonight. The roads are pretty slippery and a lot of people came here safely. And I thank you very much for that. In my language, they say that, Peel Watershed, to win the barn plum and the snake. They call it that Black Sand River. In my language, it's called Se Na-Cho Tige. So we're fighting hard to protect that. With your help, Tonti, we are going to succeed. Na-Cho, amen. Thank you very much. Before the panel here gets started, I'd like to say a few words on how I feel about the government decision of overruling the judge's decision of protecting the Peel. We as Native people, this is how I feel. As a Native person working out in the Peel Watershed for many, many seasons as a guide, when I heard about the judge's decision of overruling the government decision of development in Peel Watershed, and it was turned down, I was very, very happy. I was so happy that the 2 girls here, Shirley and Eileen, interviewed me. And I was so happy I started to cry. And I couldn't speak anymore after that. So with that, as a Native person, for me, I personally feel that this is enough. of us being pushed around, of us being driven off our hunting traditional territory, of our best hunting area, fishing area. And the hot spring out there on Nash Creek, I want that really, really protected. And I don't want to see no development of any sort in that area. And throughout the Wind, the Barn Plume, and the Snake. That country out there is so beautiful. I was telling the two girls from Chick and Port McPherson here earlier, as a guide, sometimes I see a bubble of water coming out from underground, and I jump off my horse, my saddle horse, and I dip a cup of water and drink it. It's very, very cold, and I want to see all that protected. We have a history out there of our traditional ancestors had been out there. And there's campsites, trails, and there's one place at a lick, and there's a pole sticking out where they had, long time ago, they set snares on that pole, just that one pole, and they would drive the sheep towards that pole, and they would catch at least one. That's how they survive. Our elders had said, our past elders had said that hard times are coming. Hard times are coming. We got to teach our younger people how to survive out in the bush, how to hunt, fish, set snares, and what to eat and what not to eat. We have a lot of traditional value out there. When I talk about our traditional value, I'm always thinking about our traditional medicine, the berries that we eat, we pick, and the roots that we harvest in the summer and dry for the winter and use in the wintertime. That's how our people survived a long, long time ago. There's a young lady here sitting in the audience. Her dad, little Dave Moses, even though how big he was, he jumped in his canoe, he goes out to Nash Creek Hot Spring, and he really enjoys himself out there. And that young person I'm talking about, the young lady I'm talking about is Lisa Moses. And Rose Lemieux is here too, who's related to Dave Moses. Dave Moses is her uncle. And a lot of us in the past had been out to the Peel Watershed. They had canoe down that river. But me, I've ridden all over that country by horseback. And I was lucky enough to become a big game guide for an outfitter named Louis Brown, 1958. I was 13 years old when I first went out there for him. And I've never stopped going until 2010. That was my last time out there guiding. And I don't intend to quit going out there. And with the people asked me to speak and continue to help, say something on Peel Watershed, I more than gladly would do it. And I thank you very much for all coming out and supporting in protecting the Peel Watershed. Much enjoy. Thank you.
Thank you, Jimmy. Thank you for giving us that flavor of the land and the water. and of your time out there, because that's really what this is all about. It can get very lost in paperwork and legal proceedings, but that is what it is all about. Thank you, Jimmy. So we decided to hold this meeting because so many people have been told us how frustrated and angry they are that the future of the Peel Watershed, which was given such clarity through Judge Vale's decision, which came down in December the 2nd, and how it's now hanging in a limbo again. And people have been asking us many questions about the appeal, how it works, the timing, all these sorts of things. So we thought we would hold this meeting to tell you what we know. And we don't have answers to all the questions, but we will share with you what we know at this point in time. And our plan for the evening is that each of the panel members here will make some introductory remarks and provide some background for the court decision and what we currently know about the appeal process. And after that, we'll open the floor to questions. Without further ado, I'd like to hand the microphone over to Chief Ed Champion and going down the line here.
Thank you, Jill. I'd like to start off by saying thank you to everybody for coming out this evening, and it's always encouraging and wonderful to see such support and so many people behind this effort after this many years. And with that in mind, I'll keep it brief, but it's interesting to question where are we going with this. I mean, what Jimmy speaks with passion of what most of us are looking at accomplishing with the appeal, but what's really going on here? And to me, I've really looked at this, and I'm very concerned that the way this is going is that it's actually a very strong attack at our final agreements and all of the First Nations in Yukon, not just us. It's everybody that's being attacked here. And I think that's the seriousness, and I'm trying to figure out, why is this government doing that? What is it that they're missing? And I before I come here tonight, I went over again reread the umbrella agreement, just seeing if I was missing something. And I'm not. I think the Yukon government is missing something. And what they're missing is that the final agreements are in place because First Nations have agreed to work together with Yukon government and all Yukoners in working out a process for land use planning. And when the government says they're concerned about their final authority, maybe they should do what I did, reread that agreement. Because it's clear what the process is. And in that process is where the authority lies. And that's what's being questioned right now. So this fight isn't over. We cannot stop. This isn't just a court case. This is a way of life that's going to be preserved and fought for. Na-Cho.
Dren Hozo. I'm really happy and pleased to be here with everybody tonight. Thank you all for coming. I would also like to thank and pay respect to the Kwanlundun First Nation and to Hwëch'in Council for allowing us once again to meet in their traditional territory. The day we heard about the government announcing that they would appeal, it was a disappointing day for my citizens and myself, especially our elders. Our elders hoped that this was settled once Judge Vale made his decision. This has been going on for quite some time now, and our elders called for the planning in the Peel region in 2002. And we've all participated in good faith in all the consultations. And our citizens want to feel rested from this, to move on to other pursuits. But on the other hand, now that the government has appealed, we are committed to pursuing this as long as it takes, because we must protect our final agreement and the Commission's recommendations for the Peel Land Use Plan. I had the opportunity to meet with our Elders Council a few days ago, and they reaffirmed to me that they are committed and behind supporting and protecting our final agreements as well as the Peel land use plan. The government is, in our view, is misstating our final agreements. They're not respecting our final agreements. As partners and signatory to our final agreements, they need to take into consideration the interpretation made by Judge Vail. Because I really feel that they're not taking that into consideration. Yukon government needs to move the government forward and put these kinds of things behind us. There's been one court case after another with Yukon First Nations in the Yukon, and issues just can't move forward in a mutual and respectful practice. As stated by Justice Vail, our agreements have to be interpreted and implemented in a manner that provides reconciliation. Specific words and clauses in it cannot be cherry-picked in a narrow way that defeats the objectives of our agreements. And that's what's being presented to the public every time the Premier speaks on this issue, on the appeal. Chapter 11 has to be read and understood in the contents of the whole agreement. Specific clauses in Chapter 11 have to be read and understood in the contents that the agreement works together. Like the judge said, it's a lattice work, which means weaving all of the pieces together throughout the final agreement. Together to create the fabrics of our treaties, which are the highest laws of this land and which the government of Yukon is legally obligated to respect. As we have stated on numerous occasions throughout the process, the Peel Watershed has unparalleled values to our people. In the words of our elder Percy Henry, the Peel Watershed region is our breadbasket and our university. And like Elder Johnny says, one day hard times are coming and we're going to have to depend on this piece of land to be able to provide for us. Yukon government says the appeal is their reasons for our economy. The Peel has not had any activity in it. And good relations with Yukon First Nations, as well as respectful relations in implementing our final agreements will improve our economy. Investors will not support industry or a province or territory if they have a chaotic environment, and that's what we've been dealing with here in the Yukon. Yukon government says that 7% of Yukoners provided their responses regarding the Peel land use plan, which he called minority of Yukoners. What he ceased to mention is that out of that 7% who responded, 99% opposed the recommendations made by the Yukon government in terms of their plan. So when election time comes, that majority of Yukoners who oppose appeal will be there to vote and provide for a strong vote for Yukoners. We ask Yukoners to continue to support this cause, not only for us today. We're determined to protect and preserve this land for our future generations. And once again, thank you and the Yukon people for supporting this cause. It's important to every one of us. It's important to Yukon First Nations final agreements. And we hope that, it doesn't go beyond this. So, thank you again.
Good evening, everyone. My name is Christina McDonald. I'm the Executive Director of the Yukon Conservation Society. Great to see you all tonight, and wonderful that communities across the Yukon are also tuning in. Jill asked me to review the Yukon Supreme Court judgment that Justice Vail released on December 2nd. And it gives me great pleasure to do so because it's a wonderful ruling. But it's also important because the appeal, which Jill will be speaking to next, rests upon this judgment. YG, Yukon Government, has appealed Judge Vale's decision because they are seeking clarity and certainty. And I say, and I think we all say, that for both those things, you need look no further than Justice Vale's decision. As Chief Champion and Chief Joseph have spoken to, this appeal only brings uncertainty, and that's not what we want for the Yukon. So the essence of Justice Vale's ruling, I'm just going to sort of review it quickly, and then I'm going to sort of take us back through the history of how we got here, because it's been a while, and then I'm going to dive into a little bit more detail. So, essence of the ruling: 1, Yukon Government didn't follow the land use planning approval process because it did not properly conduct final consultation. 2, Yukon Government's approved plan is quashed. 3, final consultations must be redone on the Commission's final recommended plan. And 4, Yukon Government is constrained in the modifications they can make to the Commission's final recommended plan. So that's the essence of the ruling. Now, how we got to this point in time, I think it's worthwhile just reviewing in brief, so I'm going to do that now. In 2004, the Peel Watershed Regional Planning Commission was established. 2009, over 4.5 years later, they produced a recommended plan. And this recommended plan, 80% of it had a high degree of protection in the form of special management areas, 20% as integrated management area with industrial activities focused in that region. So the next stage in the planning process, Yukon Government can opt to reject, modify, or approve the recommended plan. Yukon Government opted to modify this recommended plan in February 2011, and they provided the Commission with 5 modifications, and I'm going to go through them because they are significant in Justice Vale's ruling. So number 1, they requested more balance in the plan. Number 2, they asked for new options for access to the area. Number 3, they wanted a simplification of the land management regime. Number 4, they requested that the plan be revised so that the parties are responsible for implementation on their land. And number 5, they asked the Commission to develop a high-level, streamlined document. So the next step in the land use planning process is that the Commission considers those reasons, decides on changes, and then produces a final recommended plan. And that's indeed what the Commission did. They considered those 5 modifications, and they made changes in response to the last 3 modifications, but concluded that the first 2, regarding balance and access, were too general for them to respond to. There was no information provided about why Yukon Government wanted those changes or where they should happen. And then the Commission produced the final recommended plan on July 22nd, 2011. Now, the next step in the land use planning process is that Yukon Government can approve, reject, or modify the final recommended plan. There was an election in October 2011, and then in February 2012, Yukon Government announced it had new principles and tools to guide plan modification. There were consultations where we all made it very clear what we thought about those new principles and tools. And in January 2014, Yukon Government approved a plan that opened 71% of the Peel Watershed to staking, a far cry from the Commission's final recommended plan. So what happened next is more recent history. We, the plaintiffs, with the Hwëch'in Tribal Council supporting our case as an intervener, took the Yukon Government to court in July and October. At those hearings, we sought a very specific remedy from the Yukon Supreme Court. And that brings me to Justice Vale's ruling, because essentially what we asked for in our remedy is what we got. Chapter 11 of the Yukon First Nation final agreements has not been previously has not previously been interpreted by the courts. And so government conduct in that context has not been evaluated in a judicial review. And that's what makes Justice Vail's ruling all the more significant. This is a historic judgment of constitutional significance because it involves land claims agreements and treaty rights which have constitutional protection under Section 35 of the 1982 Constitution Act. Justice Vail's ruling describes government's process as impermissibly flawed and concluded that their process neither respected the land use planning process nor interpreted the land use planning process in the honorable way expected of the Crown under First Nation final agreements. So, let me dig into what that ruling declares. 1, Yukon Government failed to follow the land use planning approval process because it did not properly conduct the final consultation and introduced new modifications that were not presented to the Peel Planning Commission. And those new modifications, of course, were their new concepts and tools, which they brought forward at the very last minute. Justice Vail's ruling orders that the final consultation and the government-approved plan be quashed, which is a legal term for rejected or voided. Yukon Government must redo final consultations with First Nations and affected communities. And the significance of this point is that they must redo final consultations. That's the point in the process where Yukon Government took things off the rails. Up until then, things have been conducted in a collaborative manner according to the process. However, at final consultations, Yukon Government departed from the process. And so Justice Vail is ruling that we must return to that point in time, but no earlier. And further, if Yukon Government wants to modify the final recommended plan, those modifications must be limited to modifications 3, 4, and 5 that they proposed earlier. And if you remember, I said that these modifications were going to be important. Modifications 3, 4, and 5 deal with simplifying land management regime, revising the plan to reflect the parties are responsible for implementing the plan, and developing a clear, high-level document. Justice Vail has ruled that modifications 1 and 2 regarding balance and access are off the table. So this means, ultimately, that in final consultations, Yukon Government cannot submit their plan, which they've approved, the plan that dramatically increases development and access in the watershed. You know, in essence, Yukon Government can only propose modifications that the Commission has already considered and incorporated into the final recommended plan. So, home run, slam dunk, call it what you will, but this is a decisive ruling that provides both clarity and certainty. Unfortunately, but perhaps not surprisingly, Yukon Government has appealed this ruling, and Jill is going to take it from here.
Thank you, Christina. That was very useful for all of us to go over that and just remember what's happened and how historic Judge Vail's ruling really is. So I thought I would just talk a little bit about the appeal itself. As we understand it from our lawyers, an appeal deals with issues of law and how those are applied in the judgment. So the appeal won't go over all the evidence and the facts that were presented during the trial. The court will have all that information already. The judges will have had plenty of time to familiarize themselves with that well in advance of the hearing. There will be 3 judges. This is the Yukon Court of Appeal. 3 judges. Often the judges are from the BC Court of Appeal. They can also be from the territories, from Nunavut, Northwest Territories, and the Yukon. And our lawyers have told us that there's a standard process for delivering documents, etc., in an appeal. So I'll just go over that because it gives you some sense of the timeline we're dealing with here. So 60 days from the date of appeal, which was the December the 30th, 2014. The government has to file a complete record of the trial, all the written arguments, a transcript of the court proceedings, and all the documents, the evidence that was presented. And so 60 days from the 30th of December takes us to the end of February, around February 28th. After that, government has to file what's called its factum, which means its argument, basically why it is appealing. And they have 30 days to do that after the first 60-day period. So that takes us through to the end of March. We figure it's around March 30th. And then following that, we have 30 days again to file our response, our argument. And that takes us through to about the end of April, which is April 29th. So we've got quite a long process here. After that, normally that's when the judges will set a date for the hearing. They might have a pre-hearing case management conference, as it's called, a meeting with our lawyers and the government lawyers to discuss aspects of the trial or whatever. We don't at this point in time know anything about the date for the trial. Tom Berger has told us that it'll probably be a one-day hearing, and that it hopefully will be in Whitehorse. He believes it will be in Whitehorse, but we understand that the Court of Appeal normally only sits for 1 or 2 weeks a year in Whitehorse. The rest of the appeals are heard in Vancouver. So we don't know for sure it'll be in Whitehorse. We certainly hope it will be. Beyond that, we, of course, will keep you informed on everything we know about this. But looking at that timeline, you can see that it's probably the fall or the winter before we have a hearing. What Mr. Burgess said was that the earliest he could possibly see it happening would be in the summer. And that would only be if there was specific requests for it to be heard early, because normally these things do take considerable time. So, I said we don't have all the answers here. We don't have a whole lot of information about the appeal, but we did want to share that with you. And we are going to open the floor to questions now. I'd like to just go through a couple of housekeeping details. First of all, for people in the auditorium here, we do ask that you wait until the microphone, which will be brought around, comes to you before you ask your question, so that people listening online through the camera up there can hear your question. We ask that you keep questions brief, and I mean questions and comments. We do expect that some people will want to say something, but if you could keep it down to 1 or 2 minutes max, we'd appreciate that, because I think there will be a lot of comments and questions tonight. And please do be respectful of the fact that this is a public broadcast. There are people listening all over the Yukon. And on the online streaming, there is a chat line for questions for people from the communities who can send in their questions. And Amber, who's sitting over here, is going to direct the questions. We will take as many questions as we can from the communities as well as from the floor here. Yes, so we have a point from the media asking if you could first identify yourself with your name, your first and second names for the media when you're asking your question. Thank you. And I would like to say that, just to make a note, that the views expressed here tonight are by members of the public, may not necessarily be those of our organizations. Of course, people are welcome to say what they would like. But like I said before, if we could keep it respectful and brief. So I'd like to hand the floor over, and Amber, if you'd like to continue. Thank you.
So we've actually got a question that's sitting in the queue from Dawson. There's a group sitting at the Cultural Center in Dawson City, and they asked a question while the panel was speaking. So we'll start with that, and then we'll open it to the floor here. So their question is, you four are the respondents in the appeal. Has the plaintiff revealed the text of their appeal? Thus far, we have only seen the press release and the democracy speech from the Premier. Democracy is in quotations.
My understanding of that is that they have not given the specifics as to what points of law they want to deal with. If you remember earlier, both Jill has mentioned that it's a one-day court appeal and that is contained to points of law regarding what has already been said and done. So they have not identified what those points are right now. So we're shooting a little bit in the dark. But I suspect, yeah, that's the answer.
Yeah, so as I was saying, and this is totally correct, until we see the government's argument in the written factum, which comes in about 3 months' time, we won't actually know what they're appealing on in detail.
Hi, my name's Gord Bradshaw. In the early days of this discussion, the appeal was talked about as going to the Supreme Court, and I understand that the Supreme Court has the option to not hear an appeal. Does anybody know whether this court, the Yukon Court of Appeal, has that option?
The Supreme Court of Yukon normally hears all appeals, but the Supreme Court of Canada only hears maybe 20% of cases that are submitted to them.
So we'll take another one from the stream as Roxanne gets the mic back. And it's the person's identified as CKS admin, and they would like to know who will dedicate themselves to direct action if or when the appeal is granted.
I think the answer here from the panel seems to be we don't quite know what that means. We're obviously taking this through the courts as respondents to the appeal. Maybe that is directed more to the public sitting here.
Just before this question is asked, we have a request from the live stream to please hold the mics close to your mouths so they can hear you.
Okay, my name is Peter Becker, a writer from Whitehorse. Would just like to make a narrow remark to the term by the government of the public government and public land, which I believe is not just spearheading an attack in the in the court of the public opinion, but it's also an attack in itself, which I think is problematic because it's not part of the constitutional the language of the constitutional laws and conventions in Canada, and in its combination, I believe it's either 100% or close to or is 100% invented and fabricated. It implies that First Nations are supposedly second-class governments without nation-to-nation status. My concern is that it's not so much that it's an expensive piece of fabrication, but also of very high quality. I noticed that some of the people who oppose, who want to protect the appeal, have started to validate and reiterate this language frame of the government, which might not be the best idea going forward, because I mean it would be, and they have not clarified that it's not okay to attack the law by bastardizing its language.
And what is the question? I mean, it's the comments.
It's a remark. it's a remark. I think if we don't, if there is not a little bit of a better discipline in recognizing that this is a high quality, dangerous attack, on that there might be a price to pay.
The microphone is just making its way around here.
Yeah, people are just wondering how to get the mic. So essentially, if you throw your hand up, I can see you up here, and so I can point, and Roxanne, who's moving around the room here, will be able to bring the mic to you. Okay.
Okay, I got 3 questions. My name's Larry Iampin. I've been in the Yukon since '73. I have 3 questions. How come the government of Yukon doesn't have a representative here? Seems pretty one-sided. How much of that Peel is under land claims? And why was this the original one changed? And who changed it?
The Yukon Government is welcome to come to any event. It's an open door. We would welcome their participation. Number 2, the reason that's within our, well, it's in our most of it's within our traditional territory. Very little of it is actual settlement A or B land, if that's what you mean. Yeah, so Na-Cho Dun's got about 2,000 square hectares of A and B of A land, 2,000 of B, roughly, and none of that is in the Peel Watershed.
So why is the natives? I understand. I'm for the Peel, but I understand why are the natives involved so much? Because only that's a small percentage to it.
That's an excellent question, and again, that comes to the heart of what this issue is that the traditional territory, when the final agreements were negotiated 20 years ago, that was what was in that final agreement, is that what was Crown land or traditional territory would be under a land use planning process, and that land use planning process is laid out in the umbrella agreement. And this is what's happening right now, is that the government has unilaterally moved away from that process that we have all agreed to. As First Nations, as Yukoners, everybody has agreed to that process. That's the question. How can they
my name is Linda Leon, and I just have a couple of questions. You said that the appeal could be heard as soon as 3 months. Could it be delayed even longer? And when is the next election?
So, yeah. I think that the actual hearing of the appeal would not be before the summer. 3 months is the time during which government has to file its documents and its argument, and then we have another month to file our argument. So that takes us to the end of April from when the appeal was made. So the hearing date would probably be set well after that. So we're looking at a hearing sometime between summer, fall, winter this year, I think. Possibly it might be even longer, but I don't really, that's up to the Court of Appeal. And the next election has to be held by October 2016. So those are the parameters.
So we're going to take one from online and then on the floor again after that. So the question is, it's from Dwayne O'Coin, and his question is, the Yukon Party is using taxpayer dollars to attack the final agreements, which both Canada and the Yukon signed with First Nations. Will the final legal bill be sent to the Yukon Party?
I guess we can't answer that question, really. That question would have to be directed to the Yukon Party.
Jean-François Delaurier from Whitehorse. I just clarification on you've answered my question partially earlier. This is being appealed in the Yukon Court of Appeal. Is there a further step? Could it further be appealed in the Supreme Court of Canada?
This case could go as far as the Supreme Court of Canada, but it would also depend on the Supreme Court of Canada if they accept that submission. Just to add to that, I do believe that, you know, if it did end up going that far, that this would be a case that the Supreme Court of Canada would review. They've been dealing with a number of First Nation court cases across Canada for the past 10 years now, and that number seems to be growing.
To add to that, we are very confident in Judge Vale's decision. We are very confident in our chances of winning at the appeal. So we are confident. Thomas Berger, our legal counsel, is very confident.
Supreme Court of Canada would have the final answer if it went that far. No, it's in the Supreme Court of Yukon, or Yukon Court of Appeals. The Yukon.
We've got a question over here, guys. Jimmy's been waiting to ask a question.
Okay, hot dog. My name is Jimmy Jordan from Mayo, Na-Cho, Nyak, elder. There's a guy over there sitting there, asked how come the First Nation are involved. Well, maybe I can answer that question. From Northwest Territories, Fort McPherson, Chick, and Satu, and TH from Dawson, and Na-Cho, Nyak. They have traveled up in those area for many, many years, long time ago, even before the white man came up. And they have followed the animals to survive, and they have various places where they can fish, and they follow the streams, and everywhere they go, as the elders, as the guides, there's 2 elders, 3 elders told me that, you know, wherever the river flows or the creek flows, you go follow that creek, you're going to find a lake or spring water from the mountains where it creates the river and the creek. And when you find a lake, you're going to see little circles when you get to the lake, which means there's fish in those lakes. And there's moose around all those lakes. I know, I've been there. I've been up in the Bon Plume, the Wind, the Snake, the headwater of the Snake, the headwater of Stewart, the headwater of Bon Plume, the headwater of the Wind. And from the Wind and the Snake River, I've seen these 2 rivers from the headwater to the Mull, which flows into the Peel. But one day I'm going to be brave enough to try and conquer the Bon Plume River, which is the dangerous river up in that area right now. So with all the NWT and Yukon First Nation, they have travel, and some of them have settled in Mayo to where they never gone back to their hometown, which is Fort Good Hope, Fort McPherson, and Chick. So it's something that I'm very proud to say that I am a proud Northern Shoshone of the Yukon Territory to be involved in this Peel River watershed protection. And I will do my best and to my knowledge to provide all the information that I know of that country. Thank you.
Thank you, Jimmy. Good evening. My name is Ed Schultz, and first I want to commend everybody for their involvement in trying to protect a very key ecosystem for our territory and for all Yukoners. And one of the things that the Premier has been suggesting, that this is a threat towards democratic public government, seems contradictory to what I've been familiar with over the last 30 years in my involvement in the land claims and treaty process. May he be reminded that it was democratic governments, both in Ottawa and in Whitehorse, in the legislature, that through a democratic process adopted the arrangements such as the land use planning process. And I find it absolutely apprehensible that this public government got us as First Nations to go into an arrangement with them on good faith, and it's already so early in the game, because I thought it'd be dead before they started it, renege on the deal. And I'm really upset and I'm really peed off. We've devoted a lot of time and effort and multi-millions of dollars of money that we spent as Native people. And taxpayers did too, Yukoners and federal people, to come to an agreement so that we could plan our Yukon just like this. And I'm kind of upset, and I just wanted to articulate that somehow. My one question I do have, though, is I recognize that this is a cost. I see a donation jar out there, and I'll throw in what I can, but I recognize that this has a broader implication for other First Nations, so I'm, in my question, is maybe also making an appeal to our other First Nations, belly up to the bar with some cash. So anyways, is anybody else helping to pay? Thank you, Ed. You've always got wise words. Appreciate it. And I think that you've opened the door to a conversation that has to be had, and that is that the final agreements are under attack, and this will be discussed at CYFN next week, and this will be brought into a stronger perspective of the rest of the First Nations, that this is time to come together again to protect all of our interests. And this is what concerns me, is that we've opened the door to a slightly broader issue right now, and that is really, when you start looking at the economic concerns of the Yukon, the road that is about to be traveled can be avoided by this government. This is completely unnecessary. And I'm not speechless, but I'm very troubled by the choice that's being made and the implications that it contains, because we're not backing down. We have no choice. Our back is to the wall. And I don't think that has really sunk in to everybody yet. And I think when it does, a giant is awakened. And I think things will happen.
I would just like to add to that. I'd like to thank Ed for his comments. Yukon First Nations have given up 95% of our settlement land. At one time prior to our negotiations of our final agreements, we owned 100% of the Yukon territory. We gave up 95% of our settlement land, and in order to negotiate our agreements. And as part of those negotiations, we've also incorporated into many chapters the objectives of being collaborative partners at the table in discussions and management of certain areas, lands and resources, mining, land use planning, as well as fish and wildlife. So, you know, we've sacrificed a lot, and our final agreements are not only beneficial to Yukon First Nations, they have been a great benefit to the Yukon as a whole, and they need to be honored and respected by you know, governments that we elect. And that hasn't happened with this government in a long time. There's been one court case after another, and that's going to continue because it's a growing fiend across Canada, and it's starting to be a growing fiend in the Yukon. Not too long ago, I attended the Geoscience Forum. A lawyer did a presentation there, and he said that since 2002, there's been 12 court cases in BC alone by First Nations. Out of those, First Nations have won 10 of them, 2 in the Supreme Court of Canada. So, you know, we feel strongly that we are going to win this case, and we hope at that time that Yukon Government will realize that it's time to sit at the table and work in partnerships with First Nations instead of wasting taxpayers' money.
My question goes sort of in parallel to the last question. My name is Richard Price. I'm a professor emeritus of Native Studies from the University of Alberta. I've studied treaties and land claims for the last 3 or 4 decades. And one of the things that I think one point that has to be made about your final agreement here is that this is a final agreement that doesn't just belong to First Nations. It's a treaty that belongs to all of us. It belongs to all the citizens of the Yukon, all the citizens of Canada, and correspondingly our governments. So this is something we should all be concerned about, because the future of this territory is very much at stake in how we respect and uphold those treaties and that 1993 final agreement. So my question then doesn't go to First Nations and how they're in solidarity with your 2 First Nations about fundraising, but my question goes to all of us as citizens in the Yukon as to how can we assist in raising funds for the plaintiffs who are carrying all these costs, these legal costs, forward. Now, I was listening to one of my neighbors talk the other day, and he said he was very upset that his taxpayers' dollars had to go to pay for the Peel Court case. But you folks don't have deep pockets like the governments. You need assistance from all citizens, and I'm wondering if what the organizations would have to say about what fundraising efforts will you make. Will it be comparable to what you did for the original court case, or how are you going to go about it? Can you share some of your ideas? So how do we go forward, remembering this is a treaty that belongs to all of us, and how can we protect it? Thank you.
Thank you. Yes, well, you know, it was an amazing feat. The public helped us raise over $80,000 towards the first trial, the Peel Court case in July and October. I mean, that is amazing. Thank you, everybody. Yes, we really would appreciate more help raising money with the appeal. We have already set money aside. We have had some significant donations, and thank you to the individuals and others who have made those donations. We are, as you can see, I think everybody who came in the room received a little handout, and it says, "What can I do to help the appeal?" And on the back it says, you can donate, and it says, write a letter to your MLA, to the newspapers, and volunteer to help with the work that we're doing this campaign. Because we have a lovely group of volunteers, but we are always asking them for help. And it can be everything from putting together, designing something, or handing out stuff, or helping make food for a meeting, all kinds of things. We really appreciate help. So if anybody wants to do that, we have a sign-up list. So those are sort of some simple things that you can do, and we will be, we have a number of events. Yes, there's a donation jar here. All those donations go towards the expenses of everybody. It's divided. Well, it's not divided. It's put just towards the campaign, the legal campaign. So, but we have confidence that we can raise this money. The public has been amazing. And I want to totally say that I think everybody who's with us on this, they recognize that it is us who are signatory to these agreements, as you said so rightly. This is why the environmental organizations are part of this case. It's why we do this work. It's your support that helps us keep going, because it's quite a long haul. We can see the road stretching out ahead of us, and we never quite know when it's going to end. We were so happy with the court decision in December. We all celebrated. We had an amazing party here with over 500 people coming through just before Christmas, and now we already into an appeal, and we're changed direction. We've got to get back to the paperwork and get our heads to the ground again. But as the chief said, we're not giving up, and I want to say what a fantastic opportunity it's been for us to work closely with the First Nations. We really appreciate this teamwork, and all the many First Nation peoples who now come to our meetings, the communities. We so enjoy being able to go out and visit you all, and we don't do it as much as we would like, but we feel this community building. That's what this is all about. It's about building community. It's about people coming together. It's about people working together. That is what we want. That is what everybody here tonight is saying, and that is what the Yukon needs. That is what is going to give us certainty for all industries, certainty for all activities, and it's community that we need going forward.
Just to add to that, thank you for making that point, that the final agreements affect us all. And, I've been immersed in this work for almost, I guess, 7 months now as the executive director, but even before that. And I guess I felt that I'd, heard it all, and that my skin was thick or something, but the Premier's latest interview really got me upset. And, really trying to drive a wedge into the Yukon here and tear us apart. And we can't let that happen. I know we won't let that happen. And, this court case, it's about the Peel, but it's about the Yukon and all the land use planning that happens in the future. So, I'm pretty infuriated actually now, just speaking it aloud to you all, but, we're staying strong.
So I'm going to take a question from Derek Hastings, who's online with us. And he says, as the panel suggests, this appeal is an attack. What planning is in process if the government wins the appeal? Is there a strategy in place if we lose?
Yes, we appeal the decision to the Supreme Court of Canada.
Hello, my name is Julie Frisch, and people who know that name know what I'm going to say. I'm delighted to hear that there's that much confidence amongst you that we are going to win this case, and I hope we do, but I just want to remind everybody that we haven't won it all. There are 3 other rivers that are major tributaries of the Peel the Ogilvie, the Blackstone, and the Hart. And we have sacrificed some there. We didn't get the 100% protection that some of us wanted. So while we're celebrating our win at the end of the summer or next fall, please be diligent about the other part of the Peel Watershed and protect it.
Hello, my name is Angela Sabo, and I'm, as a member of the public, first of all, would like to express my thank you to the First Nations, to CPAWS, and to CYS for the hard work they put in prior to the court case. And my question is, I was wondering if, as a result of this court case, there's a possibility to get a better understanding for the government of respectful consultation, because it seems to be still like a gray area. So I'm wondering, is there any way to design an outline or even legislation that will set up a process that has to be followed so that we can maybe avoid more consultation issues in the future? Thank you.
That's a good question, and I would address it simply that if this government followed the process that's already laid out, that is a fair process, that is a just process, then this wouldn't be happening. So if you've got a government that's not going to play by the rules, giving them more rules, I don't know if that would help. I think you need new government.
Hi, my name is Jerry Lee Bike. I guess I just have a short and sweet comment, and that is that the plaintiffs, you guys do have the support from our youth, not only from Trondheim and Na-Cho and the Hwëch'in, but across the Yukon and across Canada and even throughout the world. So that we are 110% behind you, and that we will be planning on working with you guys to do as much fundraising and whatever you guys, we can work together to keep this momentum going. So that's all. Thanks.
Thank you, Jerry Lee. It's so encouraging to hear and to see youth here. It's so important. These are our future leaders, and to hear that message is very encouraging for old folks like me.
Okay, so we have a question here coming in from one of the communities via phone. And the question is, do you think that the government had no choice but to appeal? Maybe because they're trying to protect their reputation.
Actually, I would really like to answer that one, because I have been talking to the government at any chance I have had prior to the decision, encouraging the government not to appeal, that this is a time for reconciliation. Let's rebuild the relationships. Let's move forward as a territory. Economically, there are so many opportunities for Yukon that we haven't really talked about. And one thing in particular is that one of the court cases that you were talking about that occurred earlier this year, I think in June or July, the Hwëch'in won a very significant court case in the Supreme Court of Canada. And that's causing resource companies across the lower 60th parallel to be wondering, how do we deal with First Nations? They're in a turmoil. It's an absolute turmoil. When the Yukon has got self-governing agreements in place, there's high degree of certainty here already. We have so much to work with that we could be moving forward to everybody's benefit, and instead this wrench gets thrown into the system. And for what reason? To protect their reputation? You know.
Okay, so we've got Bob, and then Dave, and then Werner, and then Jody's got one coming in from Aklavik. So just so Roxanne knows what's happening here. So Bob is here. Oh, Dave already has the mic. Okay. No, it's okay. You've got it.
Thank you. Sorry, Bob. Didn't mean to preempt the mic. My name's David Lokes. I was member and former chairman of the Peel Watershed Planning Commission. This has been a very, very long process, and it sounds like we're not toward the end of it yet. The term democracy was introduced by the Premier in his recent interview, and there's many ways of defining that term, but it seems as though he badly abused it. The Peel Planning Commission, as it worked through its process, we inherited a process from the UFA, but also we inherited a notion of planning, that it's sort of a governmental affair, and it's done by planning experts, and it turns out a product that governments want. And as we went through our process, it really became, it evolved into a people's process. We did massive consultations that I believe Tom Berger, in his former life in his Berger Commission days, would have approved of. We went to just about everybody, and that really transformed the planning process so that we ended up with what I deeply believe is a public interest plan. We didn't write it for the First Nations. We didn't write it for the conservation groups. We didn't write it for anybody. We wrote it for the public interest with respect for everybody in the Yukon. And that was borne out by almost every measure of public support possible, whether it was surveys, the consultation results we got, even it was paralleled by oddly enough, by the results that the government did in their own odd consultations. People massively supported the Peel plan. So we have an opportunity for a template here for further planning, and I guess I really wanted to have that to say, so I should at least wind up with a question to justify me having the mic. I guess my question to the panel then, is it fair to say that land use planning in the Yukon is a dead letter until this matter gets resolved? We've only scratched the surface of the planning areas. And in part to echo what Julie had to say, not only are there other rivers in the Peel that are not as well addressed as they might have been, there's a whole other territory out there which it continues to be under assault from an open staking system. And it's still open for the taking, or the staking as the case may be. Thank you.
For the time being, I think that the Premier is correct. We were in the process of working on the Dawson land use plan, and in discussions with Yukon Government, we've made the decision to put the Dawson land use plan aside until final decisions come out of an appeal, I guess, or to see where we're at. So I think that it's just stalled for now, although we still internally will continue to carry out our work on it, but that provides us with more time to do that, which is good. We only have like one land use plan that's been approved in the Yukon, and we still have 11 more to go. So not only is this like a court case costing money, but the longer a plan takes, the more it costs as well. So we do have this template, like you said, and it will be useful to all the future land use plans in the Yukon. And hopefully, we do get to that point. We have final agreements that need to be implemented, and this is a part of that process to implement these agreements. And so we need the Yukon government to respect and honor those agreements. Like, it's not just for us today. 10 years from now, this is going to continue until every First Nation has their land use plan in place. So thank you.
My name's Bob Jickling, and I have two questions which are really follow-up questions to those that have been asked already. The first one's on the financial issue. The way I see it, you folks are acting as a, in a way as a public, providing a public service to ensure that the laws of our territory are enacted. So we've got the Land Claims Agreement is essentially a legal agreement, and in response to its violation, you've stood up and you've seen to it that those laws are enacted properly. So if, or I should say, when this appeal is won, given that it's a public service, is there the possibility that the judge would order that the government pay your legal fees rather than by donation? That's the first question. And the second question is a follow-up to some points that Julie raised a minute ago, and that is and it goes to beyond. What are we going to do? The current planning plan, if accepted fully as it stands right now, still leaves a portion of that 80% that can be reviewed for future development at a later time. So I'm wondering what now might be on the table with regards to future protection. For example, a couple of things that come to mind. I'm wondering if there might be others. Are we collectively, or are you as a group and the rest of us collectively thinking about the possibility of beginning the process of having this land vetted and may potentially declared as a World Heritage Site? Is that on the table? I know you've got your hands full, but is that something we should be thinking about? And I'm also thinking about that chunk of land that is not yet protected, and how future governments might make that difficult to see that that's protected in perpetuity. Is it worth thinking about other arrangements with the federal government to give, if there's a appeal-friendly government federally, to think about maybe taking this forward as a national park? Would that be something worth thinking about? So my questions are, assuming that we win these appeals, what can we then do to tidy up this protection so that it can't unravel by an ongoing governments that wish to make a nuisance of themselves with regards to protecting this area? Thanks.
Okay, so I get to put my foot in it. From a First Nations perspective, we would be looking at this as all Yukoners, in that what can we do to move forward together as a territory. And in that context, there has to be some recognition of industry and resources and jobs and businesses. So we would be always looking for maximum protection, a higher bar being set, but never close the door 100%. So that would be our viewpoint, which may differ from some people in the room. But if our viewpoint would be a balance. We're looking for a balance. And we are looking at the future. We do have to see some industry growth and economic activity as opposed to spiraling downwards like now.
So thanks, Bob. And thanks, Ed. I could just make a follow-up comment. The intention with the Commission's Peel plan is that there will be legislated protection in the areas for permanent protection, which is 55% of the Peel Watershed. So what that exactly is a question for down the road, but that was the intention, and would be up for discussion exactly what that looked like in terms of a designation. The question you had about costs and getting money from the government, and would the judge order that? As you know, we won the Supreme Court of the Yukon case, and we are allowed to claim costs. That's part of the ruling. At this point, of course, we're going to an appeal, so I think we're all agreed that we would probably wait until we see the result of the appeal as to how that would go. I mean, costs are calculated on the basis of there's a way of calculating costs. It's not the entire cost of the case that you get if you win, or that you have to pay if you lose. And I think it's something that we'll look at down the road. So I don't have a full answer to that question, but I don't think the judge is going to order that somebody else pays for the case to move forward to the Supreme Court of Canada. We do have to raise that money. Yeah.
We're all eager to get on with the implementation and monitoring of the plan. And there are provisions in the plan that say that, the plan can be up for review and amendment. So those are things that can happen within, it's up to the parties, I think, to decide the timelines. It could be 5-10 years that the plan is up for review or amendment. So, this is, once the plan is approved, it's, we still have to be diligent. We still have to monitor very carefully. There are aspects of the plan that still need some fleshing out. So there still will be work to be done, but like I said, we're all eager to get on with that work.
So I have a comment from a Klavik, sent in from a Klavik, from Bobby Joe Greenland Morgan, and she says to the panel here, giving a message. Our message is that there's lots of support from our region. A Klavik is up on the Peel River, and we are behind everyone involved in the case. And I, Bobby Joe, have roots in Vuntut land, and I'm Northwest Territories Hwëch'in, and my husband is from Trondeck Hwëch'in Dawson. We believe in this as the right thing to do for our daughter and future of our people and all people. It's about culture and overall human and environmental health. Also, this is what our parents and grandparents instilled in us, to take care of the land. Yukon government should accept defeat in the Yukon Supreme Court and work with the people. That is democratic. And she also added, she thinks that the Premier should also be holding a public meeting and having a panel. And she ends by saying, now get back to fundraising, God bless, and continue prayers.
Thank you. My name is Werner Rhein. I'm just a simple pipe fitter. On the systems I'm working, steam or hot water heating or even a hot water tank, these things have all kinds of safety devices built into. And my big question is, and that keeps me quite awake some nights, is there no safety valve in our democratic system that when somebody tramples democracy with his feet, to be able to eliminate them? Is anybody in here who can help me a little bit?
Okay, so we've got this gentleman right here has been waiting, and then we've got Keith Lay, and then we've got Kate White, and we'll see, that might be it. We'll see if we can fit any more in depending on how fast they are.
Thank you. My name is Graham McCannell. Yukoner for 43 years, not forever. As some people in this room have been here for their entire lives. I was not born here. But I've been here since while Justice Thomas Berger was doing big business, and I am the proud owner of my own private UFA in my house, and which I studied because it's, I figured it was our document, our meaning all of us in the Yukon. And it appears that it continues to this day that there's a whole lot of us and them, which is ferociously abhorrent to me. I've had the good fortune to work very closely in First Nations communities. I lived in Old Crow for 3 years, and Mayo for 3 years, and Ross River for 3 years, and the also great good fortune to have been out into this country, into the Peel country, the Wind and the Snake Rivers, Gauze Lake. Jimmy is very familiar with that territory. It's what he talks about and loves. And I've been there, spent a few weeks out there. It's unfathomably wonderful. And that's just a little feeling I had. But and a few people have mentioned it. Bob Jickling, for sure, said since this is the UFA was not for First Nations, it was for everybody. And so when our government, which is everybody as well, is taking us to court, it just seems upside down and totally frickin' ridiculous that there should be any question about which side of the table you're on. We're all at the same place. Stop.
Keith Lay. Just something I'd like to clarify. I must have missed this along the way somewhere. What's the present situation with regarding staking in the area? And secondly, what is the situation regarding people who have claims in the area working those claims?
The moratorium on staking has been reinstated for, I believe, a year. And Jill, in terms of Keith's second question, second part, can you speak to that?
Yes, the relief order for companies with existing claims in the Peel has been extended for the same period of time, so they don't have to pay money for each claim as they normally would, or do work there that is the equivalent. So both those things have been put in place, and the government has also said that there will be no oil and gas postings during that year as well.
My name is Kate White, and I got elected in October of 2011 with Lois Moorcroft. And I think it's really important that you know, in my 3 and a bit years of work, I've never been there alone. You've come out in droves at the beginning of sessions, at the end of sessions. You've come out and you've sat through, some people have sat through every single day that I've been elected. The government can't ignore you. They've tried really hard, but when you make drumming sounds outside of the Legislative Assembly, it gives us power and it distracts them, and it's fantastic. And the one thing I really want you to keep in mind right now is they're trying to exhaust you. This has been a process since before I got elected, and it's been ongoing. And the important thing for you to know is that you're growing in numbers. So there's a couple of people here that I've never seen at a meeting for the Peel before, which is fantastic. And every meeting I go to, there's more and more people that I don't recognize, and I think that's really important. But more than that is that every time you show up to something, you're sending a message. Bob has published things in the Globe and Mail with public support. Sorry, but everything you do, every action you do together, and like it's been said, it's not us against them. The only person who uses that language is the Yukon Party. The rest of us say it's us, it's our final agreements. So every time you come to something together, just know that you're showing that united front, and make sure you keep coming to the Legislative Assembly. Question period is between 1 and 2 when we're in the sitting. But if you're appalled by what happens between 1 and 2, you should see what happens between 2 and 5:30, and that's the challenge. And so if you don't like what you see on camera, then my invitation to you is try to make yourself available between 2 and 5:30. Pop in for a half hour and see what's going on, because they can't ignore you when you're in the gallery. They can't. They try really hard, and then it circulates what happens. So thank you so much to the 4 plaintiffs, because you went in front, and I was so proud of the territory when we followed in behind. So thank you for your continued fight, and I look forward to being supportive of that. And thank you everyone who has come out, because when we talk about government, we seem to only focus on the ruling party, but there is a strong opposition, and you are part of that opposition. So thank you for that support.
So we can fit one more in, and Victor's had his hand up and waving, so we're going to let him take it.
First, I would like to acknowledge the land we're on, the Kwanlin Dun and Ton Kuchan First Nation. Then I'd like to thank the panel for putting this on, the 4 plaintiffs, and then Jimmy Johnny for his words, really powerful words. I have a very strong feeling about this cause. I was born here in Whitehorse. My mother was born in Aklavik. She raised her family there, all my uncles and my aunties. I grew up in Inuvik for a large part of my life. The other day I was reading a book called The Comeback by John Ralston Saul about the new generation that is coming up. And when I see young people in the audience, that gives me hope. And John Ralston Saul put it really eloquently in his novel, where when he was describing this new generation, he said, we're facing impossible political and social situations. He said, but this generation comes from harder and more difficult situations. And he said that we're very conscious and we're very capable. So by saying that, we have an election coming up. I've heard that time and time again. And if you really want to make a difference, you got to get these young people out and voting. You got to rock that vote as hard as you can. And the Harper government has made it very clear through new legislation that they're going to make it even more difficult for young people to vote, young Indigenous people to vote in general. You know, so we need to get out to the communities and we need to educate and inform. That's the most effective way that we're going to win this battle, is by changing this government. So if this panel, if this group is willing to resource us, support us, get some of our people out into the communities to educate and inform our young people on how most effectively to exercise their democratic rights, I would be profoundly grateful. We're going to be inheriting this territory someday. We need to start exercising our ability to be good land stewards and good decision makers. So with that, I would just like to again say Na-Cho for putting this on and giving me a chance to speak. And I've always heard that speak even if you shake. And I'm shaking right now because I feel it deep, deep, deep in my heart. This is something, it's more than the Peel. All respect, it's about democracy and protecting democracy. And this is what it's all about. Thank you. Merci.
Thank you. Thank you to everybody who's spoken tonight. Thank you to all our listeners online and the questions you came with, the support we can feel from you here tonight. Thank you to my panelists here, everybody on the team. We have discussions with our lawyers. Of course, we have a great team of lawyers. We have this amazing support amongst the public. There are so many teams involved in this. It's a pretty exciting time, and I think you captured that too. Thank you for mentioning the young people, because that's, as I said earlier, that is the future. And so, everybody here tonight, thank you for coming. Thank you for all your questions, and no doubt we'll see you again soon. Thank you.
For those who want to get their picture taken and make some comments, we'll be out in the foyer.